Have you heard of the term probate and want to know how long it will take in the state of California? I'm Neal Bartlett, founder of Island View Law, and we help people protect and transfer their assets from one generation to another. And on this video, I'm going to walk you through how long the probate process takes in California. If somebody left you an inheritance, or you were left in charge of managing somebody else's estate because they've died, you're going to be familiar with the term probate unless they had a trust. Probate is a legal process that occurs after someone passes away. It involves validating the decedent's will, assessing their assets, paying off debts, and finally distributing the remaining assets to the beneficiaries. And if the deceased did not leave a will, the estate is distributed according to California's intestate succession laws. The probate process in California can often feel intimidating and confusing, particularly if you're unfamiliar with the legal intricacies involved. This is why understanding the timeline of probate can significantly alleviate some of the stress and anxiety. The duration of probate in California varies depending on several factors, but on average, it takes anywhere from 9 months to a year and a half to complete. Here are some of the major steps involved. The first step is to file the petition. This generally takes between 1 to 2 months before the petition is heard by the court. The process begins when the executor or an interested party files a petition with the probate court. This step includes submitting the will, if there is one, and other necessary documentation to the court. Second, you have to provide notice to all the heirs and the creditors of the estate, and this process takes between 1 to 3 months. After you file the petition, the court will schedule a hearing, usually 30 to 90 days after the filing. In the meantime, notices must be sent to all the heirs and creditors of the estate. Creditors generally have 4 months to file any claims against the estate. After the hearing on the original petition, you'll have to file an inventory and an appraisal, and this should be done generally within 3 to 6 months. The executor must take inventory of all of the deceased assets, which may include real estate, bank accounts, stocks, and their personal property. An appraisal must then be conducted to determine the fair market value of these assets. Over the next few months, the executor is responsible for paying off debts and settling any outstanding taxes. This can be one of the more time-consuming phases, especially if disputes arise or if the estate involves complex financial holdings. Once all the debts and expenses are paid, the executor can then go back to the court and ask for permission to distribute the estate to the beneficiaries. Now, there are several factors that can influence the duration of the probate. For example, if the estate is extremely complex with many diverse assets, that can take longer to appraise. If there are any disputes within the estate between beneficiaries or creditors, that can add significant delay to the process. Court scheduling and backlogs can also affect the timeline. This is particularly the case in large counties like Los Angeles. And lastly, the executor's ability to manage and expedite tasks can either shorten or extend the process considerably. As you can see, the probate process is extremely complicated and it can take a very long time, but it can be avoided. If you're planning an estate, you can usually avoid it by having a revocable living trust. But if your loved one is already gone and you're stuck going through the probate process, consulting with an estate planning attorney can provide tailored advice to help you through the situation as quickly as possible. If you need assistance with probate, or you're considering a trust but need help figuring out where to start, contact us today. Schedule a 30-minute call with our firm and we'll analyze your entire situation and provide a plan to protect you and your assets.